Troy Michler.
Yeah.
So let me pull up Odyssey. Just give me a moment.
Yes, ma'am.
You've got deadlines, deals, and delays. If you've ever wondered how plea negotiations really work, this is it, a legal chess match behind the scenes.
All right. So on this case, do you have all of the discovery?
We do, Judge.
Okay. And has she tendered an offer or no?
We have an offer. We're going back and forth on that, Judge. Today is the plea deadline. But I don't, because she's in trial, I don't think we're in a position to submit that to the court.
All right.
So
We're going to extend your plea deadline date, and this will be the final plea deadline date. Excuse me, does anyone remember the special prosecutor on Michel?
It's Miss Creswell.
Oh, okay.
It's Miss Creswell.
All right, didn't she say she was going to be on vacation at some point?
Yesterday, and the day you gave her was August 4th, I think. And she said she would have to send someone else.
I know her schedule because we've been talking quite a bit. She's in trial this week, Judge, and then the next week she's out. So our opportunity to talk and nail down the moving parts would come presumably after she's back.
And when is that?
After next week. So
The week of August 4th?
The first is Friday.
Yes.
So that would make...
Notice the judge's tone here. This is the final deadline date. Translation: the court's patience has limits. No more extensions, no more excuses.
She'll be out that next week, so it'd be the second week of August is when she's back, Judge.
All right, this is an old case. And I know it's not an old case in the sense of when it was indicted, but this will be your final deadline date. There will be no further extensions. So you all have to confer off record. Norma, can you put this for August 12th as a final deadline date? Will you be here or no?
I'll be coming back from Louisiana that day, Judge, because we're moving my son over to Tulane.
Look at you. I should hold that against you. LSU is right down the road and you're doing Tulane. Okay.
So we just have even a few more days.
What do you feel about Tulane as opposed to becoming an Aggie?
I think it's a good fit for this. For my younger son, it's a great fit.
Awesome. So when will you be back?
We'll be back the 12th.
All right. So Norma, set this for August 14th.
I'll be here, Jen.
All right. Safe travels.
Thank you.
Once you sign the reset form, you're excused.
Thank you.
All right. Thank you.
I'm covering that for Joanne de Hoyos.
All right. Are they on bond or in custody?
I verified they're on bond, and prior to putting bond, I had done a fax letter to the jail.
Mm-hmm.
I know he's with the company bond, but we faxed a letter to the jail. There's no way we couldn't get that letter with our contact information, and we scheduled a jail visit. But I don't believe it showed to that. I don't have my laptop with.
All right. And so, and the bondsman has no idea?
If you would like me to...
I mean, do you want to call them to check in with them? And then, or if you want it heard now, I'll hear it now.
I can call in, but...
OOF. When a defendant openly says they want their lawyer gone, you know courtroom drama is about to unfold. Question for you. Do you think defendants should have the right to swap lawyers mid-case? Or does it just stall justice?
I would have to come back later this morning, fairly busy.
Sure. Okay. Adriana Ramos?
Mr. Sullivan present, Your Honor?
Yes. All right. So there's a motion to withdraw?
Yes, ma'am. She called me yesterday. She wanted me gone, and that's fine. She wants a new lawyer. I hope the court can give her one.
Well, I mean, is she going to hire an attorney?
No, sir. No, ma'am, that's not what happened.
All right. What's going on?
I had to call the MAC number yesterday for the second time. I've been having many problems with Mr. Boyd. He's very unprepared when we come to court.
Mm-hmm. Well, just 1 second. Let's do this. So I'm going to have you remain, and I'll have managed assigned counsel come down.
What does that mean, ma'am?
Oh, the MAC attorney is going to come down.
Okay, yes, ma'am.
So they can see what's going on here.
Yes.
All right. Thank you. Just have a seat, okay? All right, Norma, can you have managed assigned counsel come down, please?
Yeah.
Court is calling 2025 CR 005379 State versus Adriana Ramos. Could I have parties announced, please?
That's all, Ms. Miles.
Adriana Ramos.
All right. So it is the court's understanding that your attorney has filed a motion to withdraw. Are you aware of his motion to withdraw?
Yes.
All right. So I don't do ex parte. However, managed assigned counsel just sent an email to.
Here's a big one. Judges rarely allow attorneys to withdraw just over communication issues. But this time, the court agrees. That signals some serious breakdown between lawyer and client.
The court coordinator, and the court is in receipt of that. Any objections to the court reviewing what managed assigned counsel has sent?
No, no.
All right. All right. So the email that has been sent to me, and I want to explain to you, Ms. Ramos, normally I do not allow motions to withdraw just because there's some sort of lack of communication, but based upon what managed assigned counsel has sent, I will grant the motion to withdraw. All right, you may be excused.
Be available for the next council with any questions, John.
All right, if you will just remain in court.
Y'all will.
Thank you. So then the next question becomes, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Amen.
All right, you can lower your hand if you'll state your name for the record.
Adriana Ramos.
All right, so Ms. Ramos, the questions I'm going to ask you, it has absolutely nothing to do with the facts of your case. Please do not tell me anything about the facts of your case because your attorney would not want you to, okay?
Yes, ma'am.
All right, so are you able to afford a new attorney?
No, ma'am.
All right, do you have any funds in a bank account, any savings?
Not really. My mom just passed away in May, so I just had to bury her.
Okay.
I do have a job at AutoZone, but it's part-time.
Okay, so do you have any money in a savings?
No, ma'am.
All right, so I'm going to have a new attorney appointed to you, and that new attorney is going to be Orlando Castillo. All right, so if you'll confer with him.
Yes.
All right, she said today, we're off the record. She says today for it's just discovery today.
Okay.
So that's what we're here for.
Okay.
So he'll confer with you and then he'll confer with the state and then he can approach me when you're ready.
Yes, Judge.
And on, settle, I'm sorry. Thank you.
Oh, us?
Yes.
Yes, Judge.
Hello, Hunter.
Hello, Judge.
Hi, so what is happening with these other cases?
Which other cases, Judge?
On Campion, I have a 2025 CR 007085 and some PF cases.
Or
Oh, do you know what? You all are not on Valerie Campion. You're on Settle. I'm sorry.
I'm on that one, Judge.
All right, just give us a moment, counsel.
I was like, oh shoot, I don't remember those, Judge.
I was like, I don't remember those
They can
either.
update you, Judge.
Okay. I was like, what is happening with all these cases? All right. If Ms. Settle will come forward. All right. Court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed, is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child, and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court.
They did not accept her because at the time she had not been sentenced, but I verified with felony drug court that should she be placed on probation, they're able to accept her in and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
This judge lays it out bluntly. On paper, the defendant looks prison-bound. But the human side, a child, signs of change, shifts the scales. This is where law meets empathy.
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed. But the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee-high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? Mm-hmm. And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI. Back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling in programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again.
And here's the prosecutor's punch. They are not just worried about the defendant. They are worried about her kids, her family, and the community she's already harmed. It's the bigger picture that makes this argument so strong.
PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, We're asking the court to consider probation or community supervision in some form in order to enter the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate, and if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation? Yeah.
All right. So normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Sure.
Judge, on the second degree case, is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
Okay. So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yeah, sure.
Understood, Judge.
So if you all want to change that to a cap of 10, and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settle's, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.